recall. And we have I think, an empty seat as far as I can tell for Chesa. But again, if he wanted to jump in right now, he's more than welcome to. And in that case, we will move forward, proceed with Brooke, and hopefully have a rich conversation while also trying to represent what we think the other side might be. I personally watched a bunch of videos of conversations Chesa has recently had, or interviews or presentations that he's given. So I am hopeful that that we will be able to sort of articulate what his side is on things, and have a good conversation with Brooke. Brooke, would you like to introduce yourself? You might not need introduction at this point, but please go ahead and introduce yourself and we'll get started.
Thank you, Marie. And yes, for anyone that isn't familiar with me yet, I am Brooke Jenkins. I spent the last 7 years up until this past October in the San Francisco DA's office. I was hired by George Gascon. And of course, Chesa took over in 2020. I, like anyone else who's come to the DA's office with no criminal law experience, started in the misdemeanor unit, worked my way up to general felonies, which is the unit that covers robberies, burglaries, sort of your regular type of assaults, gun possession, drug sales. I was also simultaneously the hate crimes prosecutor for almost 2 of the years that I was in that assignment. I then was promoted to the sexual assault unit by George Gascon. And then after Chesa took over, he promoted me to the homicide unit, where I spent the next 1.5 years up until my resignation. One thing that I like to share is that at the time that Chesa began campaigning, I had not taken a position intentionally to support any of the candidates. Not knowing what the outcome would be, didn't want any of them to feel as though I had opposed any of them. I wanted what was best for the San Francisco DA's office and what was best for San Francisco. And I would have supported whoever was elected. I knew Chesa Boudin as a public defender. We had a number of cases together. We had been friendly to one another throughout the course of having cases together. And he actually was the only candidate that reached out to me during the campaign, despite the fact that I knew 3 of the 4. And so I agreed to meet with him when he reached out to me. We met at a coffee shop on 7th Street, right near the Hall of Justice. And I spent an hour talking to him about my thoughts of what changes we needed in the office. He asked me a number of questions about how what I thought about what was needed in the DA's office. And also he asked me how to build trust with the attorneys who he felt were skeptical of his campaign. And so we discussed that. And one of the things that we discussed was a fear that many attorneys had about him potentially firing many of us. And so he assured me at that time that was not in his plan. He wanted me to take that message back to the office, which I tried to do. And so from the start, I tried to be supportive of Chesa because if he had, believing if he had won, I still wanted him to be successful in the job because that's what was best for San Francisco and the office should he have won. And so I want to start by saying that because I want everybody to understand that I did not enter this from a position of skepticism or even just being against him from the start. I wanted him to succeed at the time that he was elected. But what I quickly noticed was that on day 1, when he fired 7 of our most experienced prosecutors, including 4 managers, one of whom was the only African-American manager in the office, a Latina manager, I did have grave concerns at that point right away, because that was not in line with what he had expressed to me during that meeting. And we lost a vast amount of experience in the office that day and leadership that we needed. And so from that point forward, I tried to simply continue to do my job. As I said, he promoted me. I was grateful for that. Homicide was always the assignment that I desired to be in, and move forward with doing my job. Many of you have probably heard me talk about the murder of my husband's cousin, which is what happened in the interim time, and the DA's office refusing to charge that case under Chase's position that he won't use gang charges under any circumstance whatsoever. And so, that was another sort of point of concern for me, that we were making decisions in the office not to hold even our most violent and deadly offenders accountable where we could. But again, I tried to sort of focus on the caseload that I was assigned, and move forward, and ended up trying a case involving a very heinous murder, and secured a guilty verdict in that case. We moved forward from that point to the second phase of the trial, where the defendant had the responsibility to prove that he was insane at the time of the murder, because he had entered a plea of insanity. That played out where just Chase and I had a little bit of back and forth about whether or not I should even move forward with that phase of the trial. I told him I believed we should. The jury ended up hanging on the seventh day of deliberations. It was a very long deliberations process. On the seventh day, they came back saying they weren't able to agree. They were stuck at 6-6. And we sent them back to continue deliberating. And on the eighth day, they came into the courtroom and said, we are not going to be able to agree. And they were stuck at 7-5. One juror had switched to insanity at that time. Expecting that they were going to hang based on the 6-6 note, I made an agreement with the defense lawyer, who was a public defender, that we would allow the judge to render a decision on the issue if the jury couldn't agree. She entered into that agreement. When the jury hung, we decided that we would move forward with that agreement the following day, only to have her send an email to Chesa and myself outlining why she wanted Chesa to simply override that agreement and instruct me to agree that the defendant was insane. And that is essentially what happened. By the next morning, I received word from my supervisor that Chesa was instructing me to agree to the defendant's insanity. What I want to be clear about, since we have more time than what I'm given in a general sort of news media interview, is that my main concern in that case was the fact that the way in which Chesa went about the decision was reckless. He did not request to meet with me or have any meaningful discussion with me about the case, about the 7-week trial I had just completed, and what evidence and testimony had come forth during those 7 weeks. He didn't review any part of the case file. He didn't request to read any of the 4 expert reports, which were drafted by experts who had interviewed the defendant and had made an assessment of him. He didn't ever avail himself of the ability to watch that trial. And so he was making a decision that had a significant impact on public safety here in San Francisco, based simply on an email from a public defender who actually was more than just his former colleague, but his former office mate at the public defender's office. What most people don't know is that it's not a choice of prison or the mental hospital. It's not as simple as that. When someone is deemed insane, they have the right within 1 year to petition for their release if a judge determines that their sanity has returned. And so this decision put at risk a very dangerous individual being placed back into our community within 1 year, which is now just a few months from now, without any sort of ability, or he had the ability, but he didn't have any interest in making an educated decision. And so it was that was the final straw for me, that I could not continue to pursue justice in these cases and have the leadership in the office be willing to intervene in that fashion and put the public at risk. But rather that I needed to leave, and ultimately decided that I would speak out in favor of the recall.
Thank you. I have heard that story before, but didn't have, definitely did not have all of the context and detail that you were just able to provide. So that's very helpful. Why don't we take a step back and talk a little bit? Can you talk a little bit about, there are so many different players in the criminal justice system. You've got the police department, judges, public defenders, prosecutors. Can you give us just a quick overview of their specific roles, and then talk about, well, first, can you just give us an overview of their specific roles?
Yes. And so many of us have probably watched the show Law and Order. And in the intro that talks about how the police are who make the arrests and the district attorney's office is who prosecutes the offenders. Well, that's exactly the way it works. The police, of course, as you know, are on the street and they make arrests, they conduct investigations. When they make an arrest, they not only, of course, draft a report, they collect all of the necessary evidence, and they actually book the person on specific charges that they believe the person has violated. They then take all of that and fill out a form and submit it to the district attorney's office. The district attorney's office has what is called a charging unit. It is a unit comprised of used to be a very experienced assistant district attorneys who know, exactly what they're doing. And they look at the report and the evidence, and they decide whether or not the DA's office should actually pursue those charges and file a complaint. They sometimes agree with the police, they sometimes don't. Sometimes they file charges that are different or are less, or sometimes even more serious, based on the standard of proving them beyond a reasonable doubt. That's their assessment. Once the charging unit decides to move forward with filing charges, they draft a complaint, and that complaint is filed in court. The first time a person appears in court is within 72 hours of their arrest, and they show up for what is called their arraignment. That is before a judge. They are informed of their charges. They enter a plea. Almost always that's a plea of not guilty. And then there is generally a large discussion about whether or not they should remain in custody. Generally on misdemeanors, people often are out of custody when they appear. They're cited to come back to court. But in felony cases, more often than not, they come into court in custody from the jail. And so the judge is who ultimately renders the final decision about their custody status while the case is pending. There is subsequently a preliminary hearing that judge or some other judge will hear for the DA's office to prove that there's probable cause to believe that the person committed the crimes they've been charged with. That's to ensure that we're not filing frivolous charges and then keeping people in custody unnecessarily for months or years. And then you move forward from there if the judge believes that there's probable cause towards trial, and the defendant has their right to invoke their right to trial at that point, and you get assigned to a trial judge when it's your time to hear the case.
And in San Francisco right now, is crime down?
So there's been a lot of discussion about that. And unfortunately, what I've learned through this process is that data is hard to come by. Not only is the data that is compiled and kept by the police department doesn't seem to be consistent, but the DA's office has not been as forthcoming with the data that it has, which has made it very difficult. I've seen, the Chronicle make reports about crime levels being down in certain categories. I've seen other news agencies report that crime is up. What it appears is that there are certain categories of crime that are on the rise and that have risen in particularly the end of 2021, which are certain types of burglaries, assaults, and I believe 2021 did surpass the number of murders than there were in 2020. But there are certain categories that are up, despite the fact that certain others are not.
And I would, of course, like to ask Chesa the same question, but we only have an empty chair for him tonight. So unfortunately, we can't ask that question because I know it is his position that crime is down. What one of the things that we do hear most often is the confusion around the crime statistics. I was just watching an interview earlier today where Boudin was saying that crime is down. He's charging. He specifically said in this particular interview that he is prosecuting more than his predecessors and then in other counties. And then he said, "I'm charging more than anyone else." And I'm not sure exactly what any of that means. And can you kind of tease that out for us, because it sort of got lost in the conversation that he was having with this interviewer. And I'm wondering if you can dig in on that for us.
So yes, and so we've all probably heard a number of statements from Chesa sort of touting his prosecution rates, saying he's filing charges in more cases than his predecessors. And I think the first concern that he arose after the Troy McAllister case, when Hanako Abe and Elizabeth Platt were killed. That is the case where they were walking across the street at 2nd and Mission, and Troy McAllister was driving a stolen vehicle 60 to 70 miles per hour, high on drugs, and hit them, killing them. And it became known through the press that he had been arrested 4 times since being released. And this is a case hopefully we can discuss later on in more detail. But Chesa released him while he was pending trial on a robbery shortly after he took office. And in the next 9 months, Troy McAllister was arrested 4 times. Those cases were submitted to the DA's office here in San Francisco. And each time the DA's office declined to charge Troy McAllister in those cases. The 5th arrest that he had was for killing these 2 women. And so that was on December 31st of 2020. There was quite a bit of unrest and attention on the lack of charging of Troy McAllister in those 4 cases. And so we saw a big shift at the DA's office in sort of this desire now to charge in most cases. But the reason that Chesa wants to highlight, in my opinion, his charging rates is because he wants to distract you from what's being done on the back end. Charging simply is filing a charge, right? It's you can file a felony assault at the time that the person is arrested. But if you resolve that case for a misdemeanor battery, or you dismiss that case, well, then the charging doesn't really reflect the outcome of what happened to that person, or what you believe their conduct was, or the value of that conduct. And so what we are seeing is that while many cases are being charged, it's the way that they are being resolved that is much more of the concern at this point. And much of that shift in the charging initially seemed to be the result of Chesa hiring immediately one of his colleagues from the public defender's office, a 20+ year veteran public defender, to come and manage the charging unit at the district attorney's office. And so, of course, as you would expect, when you have a public defender who has no experience charging crime and has a particular mindset that they were entitled to have as a public defender, running such an important unit where you're deciding exactly who and what gets charged, that there was a decline or something going on at the time that Troy McAllister, remained out on the street despite those arrests. And I can name other situations that are similar. But they noticed after that they had to change their approach. And so the concern now is what he's doing with those cases after they are charged.
A recent Chronicle article highlighted the diversion rate has gone up 20% and his conviction rate has declined by 20%. Isn't diversion a good thing? Isn't that something that we want for our system to be a little bit more focused on restorative justice and things like that?
Yeah, and that's a very fair question. It's something that deserves attention. And so that is one of the things that I've been mentioning when I said what's happening on the back end should be more of our focus. And what we know from Chase's own data that he supplied to the Chronicle, his diversion rates have soared, right, up by 20%. What most people don't know is there's sort of multiple tracks that you can go on to avoid prison. There's not just one. Diversion isn't the only one. When we're looking at alternatives to incarceration, we already have a set of collaborative courts, which are courts that are designed and created to address sort of those root causes of crime that Chesa talks about, that were formed by his predecessors, Kamala Harris, many of them by George Gascon. Those courts include drug court, mental health court, it's called a behavioral health court. We have veterans court, which is a court strictly for people who have, done service for this country, to access the benefits that you can as a veteran to get services. We have young adult court, which is something that was created by George Gascon for offenders who are 18 to 25. They receive a case manager. And all of these courts have a specific judge that is so that they're only dealing with one judge. That judge gets to know them, gets to know their case. Young adult court gives them a case manager. They receive vocational training. They receive help with getting their GED if they don't have it, counseling services, a number of things to sort of get their lives back on track and in the trajectory that we all would hope that it would go. And the way those courts often work is, in order to enter them, you enter into a plea. Most often, you enter into some type of plea to a charge. And the understanding is that if you follow through and complete the program, that you will be able to then withdraw the plea to that charge and enter a plea to a less serious charge, or in some cases, earn your dismissal. Diversion is something very different. Diversion is it's kind of a watered down version of that. You have to sometimes go to just some classes, be it anger management classes, Narcotics Anonymous classes, parenting classes is one of them for parental care diversion. And if you do sort of these 12 classes or how many ever they assign you, your case is dismissed. It doesn't require you to enter a plea at the outset. You just are sent there, and hopefully you complete those classes, and that's your dismissal. Historically,
and if you don't complete the classes, what happens?
Well, so that's the key here. So historically, diversion was reserved for low-level offenses. It was not a place for violent offenders or very, very chronic offenders. It was for those who, were kind of new to the system maybe, and didn't have a long criminal history. And we wanted to keep them sort of as a full citizen in society, meaning with all the abilities to do all the things that we want you to do in society. And so we gave you the opportunity to not end up with a conviction on your record, or you've committed a crime that's very, very low level. And again, want to give you the opportunity not to have that on your record. But now what we are seeing is an abuse of all of these programs, particularly of diversion. We are now seeing violent offenders being sent to diversion. Diversion is something that actually has structure and rules. You're actually not eligible for it if you've committed a violent offense. So what we're seeing happen is, and I can tell you about an example, which is of a man who committed an armed carjacking. And what happened was he was charged with felony carjacking and felony robbery, which are both serious and violent felonies. They're not eligible for diversion. But Chase's office dismissed those charges and added new charges of grand theft, which is just your average theft of something over $950, making this person eligible for diversion. and sent the person to diversion. That is not the way that diversion should work. We are also seeing people not complete the programs, not complete classes. They are, because of course you are out of custody while you're going through diversion. People picking up multiple new cases and not being sort of taken out of diversion, but being allowed to remain despite now having 2, 3, 4, even 5 additional cases, clearly demonstrating that they are not willing to take advantage of this opportunity, right? And the final thing is, there's no protection in diversion for the DA's office and for the community. Chesa talked about how in the interview with the Standard about how, well, you know, if somebody doesn't complete diversion, we can always just move forward with the criminal case later on.
Exactly.
But as a prosecutor, what we are always thinking about is access to our witnesses, to our victims. And if somebody has been allowed to flounder in diversion for a year, sometimes even more, before the DA's office says that's enough, and we haven't required them to enter a plea on the front end, we are now a year or more later trying to build a case to go to court with after so much time has passed that victims have become upset and oftentimes unwilling to move forward and help the case. Witnesses have moved away. We've lost track of their phone numbers because they've changed. It's very difficult to put together a case for a trial a year or more later, when you haven't been in touch with these people for that full length of time. And so it's very unrealistic to believe that we can just simply snap our fingers and move forward with a criminal case when we've been doing nothing with it for some long period of time. And so that's why initially we have always engaged in having the protection of having the person enter a plea at the outset, especially in the kind of more serious cases, so that we didn't have that problem. If they didn't complete the program, they already had entered their plea of guilty and they knew what sort of consequence they were facing if they didn't complete it.
So this is something that I was looking at in the Standard interview myself, that he was talking about, and I'd love to ask him, but again, he's the empty chair in the corner up there. We don't have him here, so I can't ask him. But it sounded like he was saying, you know, he's pushing things into diversion. That's so much better, which of course, I think everybody wants a better outcomes from our system and for people to go on to lead productive lives, and incarceration isn't always the right answer. But it sounded like what he was saying, that, you know, people go into diversion and very quickly, if there's a problem, they take them out of diversion and they charge them with the original crime. And it sounds like that's not actually really happening. And that is much easier to say, but it actually is much harder to do if you haven't charged for the crime on the front end.
Yes. And so what I've tried to explain to people is that Chase's rhetoric depends upon the listeners not truly understanding the system. Right? For the average person, you would say, yeah, absolutely. Okay, that's the safeguard. If they don't complete it, then you just move forward with the case. But as prosecutors, we know that that's actually very, very difficult and rarely ever happens when you've allowed that much time to elapse. And so what's happening is when we have compiled public records in a lot of these cases, and what we're seeing is, like I said, despite people picking up new offenses, despite people not showing up multiple times and completing these programs, they're still being given the dismissals, because diversion results in a dismissal. You complete these parenting classes, you get a dismiss, your case is dismissed. It goes away forever like it never happened. They're still being given the benefit of that outcome, despite the fact that they are failing at the program, at actually doing these classes.
And they commit another offense, then they're considered a first-time offender. Is that correct?
If they had no other record, yes. It's as though that prior case never happened.
Okay. We have a question in the chat that is relevant right now, so I'm just going to ask it to you. Can you speak to the efficacy of diversion programs where the convicted individual resides outside of San Francisco and therefore is not really participating in the support structures here?
Yeah, it of course makes it more difficult. A lot of these offenders don't have cars. Some of them don't, have phones. And it makes it very difficult if you don't live in San Francisco to access the classes that you need to go to. It's something that, every defense attorney and prosecutor should be keenly aware of, to know, are you in a position to actually succeed at what I'm setting you up to do? And so for someone who doesn't have a car, who doesn't have a job, and so therefore can't afford to ride BART in and out of the city, who doesn't have a phone where they could be sort of reminded sometimes about, hey, it's Tuesday, you're supposed to go to your class this afternoon, it makes it very, very difficult for them. And so CHASA wants you to believe that diversion is this arduous, very difficult program. It's actually not, for anyone that resides here and keeps up with what they're supposed to do. It's actually quite simple. You go to these classes and you're done. But sometimes for those who don't have the means, like I've just described, it can be an impediment to their completion. The collaborative courts that I mentioned, those are the programs that are arduous. Drug court requires you to go oftentimes to inpatient drug treatment. Mental health court requires you to agree that you will take medication for your mental health issue and to go to treatment programs. And so those are the ones that people oftentimes, it takes a lot to get to the point where they are willing to engage in that fashion. But there are safeguards. And like I said, specific DAs, specific public defenders, a specific judge who are there to sort of help them along the way when they stumble, to pick them back up and put them back on course. Diversion doesn't have those safeguards. The safeguard is, if you don't do what you're supposed to, then you're not allowed this benefit. And CHASA has done away with that.
Are there any stats on diversion? And some people are mentioning in the chat, like the neighborhood courts. We had a speaker on the neighborhood courts at our March event. And if I recall correctly, in the neighborhood courts, do you go into that and then they wipe clean your record and they don't really follow you? Is that?
So the neighborhood courts, I don't even think that they exist anymore, to be honest. They used to be, that was sort of an invention of trying to have community-based restorative justice, where instead of us sending you to criminal court, you sort of answer to the community. The neighborhood, right? We had community members who sat on these committees called these little courts, and they decided sort of what you needed to do to engage, and your case was not sent to the criminal court, actually. And I don't believe that those are going on anymore. This is something different and distinct. It is done through the court system. But again, it's sort of the decision on whether or not you remain in diversion is up to the district attorney's office. And we have now watered down every safeguard that we used to have to ensure that people earned the right to have that dismissal, and that we were sending the appropriate people there. People who rob somebody with a gun should not be in diversion. They should not be eligible for a dismissal for going to parenting classes. That shouldn't be the case.
CHESA ran on a platform of ending mass incarceration and reforming the system. Do you agree with those goals? Do you think a tough on crime approach would be better? Sort of, where are we now and what do we need to do?
I absolutely 100% agree with his end goals. I've expressed that from day one. The system continues to need reform. We absolutely need to continue to work towards alternatives to incarceration as our main focus. Alternatives that actually are proven to help people change the trajectory of their lives. And so I have never disagreed with CHASA on those fronts. My disagreement with CHASA has been in the execution of achieving those goals. I don't believe that sort of this soft on crime, tough on crime is sort of the right way to frame this conversation. What we are looking for, what we are calling for out of this recall is balance. Reform has to be measured. There is a way to achieve reform and maintain public safety. And that is based on the way that you execute that reform. And I'd argue that what CHASA is doing is actually not reform. to simply say, okay, you've committed, no matter how many crimes and what type, all the way up to murder, we're going to allow you back out onto the street. No consequence, no programming, no real meaningful programming, and put you back into the same circumstance that brought you into 850 Bryant Street. That's not reform. Reform is actually making sure that your attorneys are executing discretion in a proper way, right? Giving safeguards in your policies that don't allow for the disparate treatment of defendants based on race, based on gender, those types of things, age. We want to be taking an approach that is, yes, fair to the defendant, but our priority has to always remain public safety. That's the order of the district attorney's office. And I have implored people to understand that what CHASA is doing is actually putting the reform movement in danger. If people around this country in cities far less compassionate than San Francisco see what's going on here as an indication or a depiction of reform, they will outright reject it. They will maintain the broken systems that they have. Right. And we want them to see San Francisco as a model like they have and embrace what we're doing so that they will engage in change where they are. And CHASA has now, right, because this is a national headline, he's putting that in jeopardy. And so that's what we are trying to protect and promote, is a balanced approach that achieves reform while keeping San Franciscans safe, because that's what we deserve. We deserve to not have to worry that somebody's going to come into our house at night.
So in the SF Standard interview, Chesa said that every day his office is in front of judges asking for incarceration, and that the judges are letting these people go, and it is not his office. His office is in there demanding incarceration, and they're not getting it. Can you speak to that? Because that sounds very different from what I think a lot of us understand to be happening.
Well, first of all, that wouldn't align with his ending of mass incarceration platform that he continues to maintain, which again, I am for alternatives to incarceration. So the two actually don't add up. But more importantly, I want to explain the fallacy in those statements. First and foremost, there's 2 points in time where assistant district attorneys are in court discussing someone's custody status. It is at arraignment, generally, when the person first comes to court, like I said, and they come in custody, and you have this debate. The other is at the time of sentencing. Well, let's start there, actually. As we all know, the majority of cases resolved by way of plea, not trial. When it's a plea agreement, the district attorney's office has negotiated what the actual outcome of the case will be. So in particular, for example, if it's a robbery case and we decide we're going to offer you 3 years of state prison, and the defense says, okay, great, I was facing 12 years. I'm going to go ahead and jump on that 3-year deal. And we go to the judge and we say, Judge, we've agreed to a plea arrangement. And the judge says, okay, what is it? We say they have to plead guilty to robbery and they will be sentenced to 3 months in prison. And the judge says, okay, let's take that plea. And then they read this long colloquy to the defendant. The defendant has to enter a plea of guilty to that charge that we've agreed upon. And then they are told that on the date of sentencing, you will be sentenced to what you agreed to, the 3 years. If that changes, actually, we will allow you to withdraw your plea because that will nullify that deal you just made. So the judge has zero input in the outcome of sentencing because we've agreed to it as a part of the plea. There are no surprises when somebody takes a plea. That's the whole point of it, right? If somebody goes to trial, that's a little different. If they go to trial, and which is in a very small amount of cases, the judge gets to determine what the sentence is if they're found guilty. And there are parameters for that, right? If you're charged with robbery, the maximum for robbery is 5 years if you haven't used a gun or, it caused great bodily injury to somebody. And so you know that the minimum is 2 and the maximum is 5. The judge can only work within that framework. But it is completely false to say that attorneys are in court begging judges to send people to prison on plea deals, because that's a part of the agreement from the outset. The judge simply approves it or doesn't approve it. When you go before that to arraignment, the way that it works, like I said, is the person enters a plea of not guilty. The judge then says that, okay, I will hear arguments now on custody status. The defense lawyer always gets to go first. They read this long, or sometimes they do, they get to read this long dissertation that they generally give on, here's the 12 reasons why this person should be let out of custody while their case is pending. They say, they're not a flight risk. They're from here. They have a family here. Judge, the crime wasn't that bad. We're really making too big of a deal of this. He has no criminal history, or the criminal history he has, really is insignificant. They give all these reasons why the person should be let out. It is the job of the district attorney to make an argument based on public safety and flight risk. That doesn't mean in every single case we should be asking for the person to be held. Of course not. But what it means is we make an assessment. We look and see, right? Does John Smith have, a rap sheet as long as, my leg that says they've committed multiple violent crimes over and over again? Right, especially within the recent past. Is this a particular crime? The facts of the current crime, are they absolutely abhorrent and really concerning? Meaning, did they put a knife to somebody's throat and threaten to take their phone? Like, what are the facts? And you make that assessment and you say, okay, in this particular case, I believe you should remain in custody. Well, CHESA has issued a blanket policy that we cannot ask for cash bail at all. And I want people to understand, I am, again, in support of diminishing the use of cash bail. I think we need to be moving away from it, but we cannot eliminate it totally. And here's why. When you're in a universe of no cash bail, you have two options. It's release or it's detention without the opportunity to post bail. Detention without bail is reserved under the law, not Chesa Boudin, but under California state law, as for only those people who commit very serious and violent offenses or are a proven flight risk. So what really falls into that category are murders, rapes, child sex abuse, those kinds of things, very, very violent and assaults. But sort of everybody else doesn't fall into that category. We can't legally seek for them to be held without bail. And so if sometimes you have unique circumstances like the lady who was stealing from Target 128 times, right? Where she's not a violent offender, so she doesn't fall into that category. But we also are saying to ourselves, that seems like not the person that should necessarily be released tomorrow, right? After her case is charged. And CHESA won't allow the office the ability to use our discretion when we have situations like that, or maybe somebody who's committed now their fourth robbery, but it's not one that is particularly violent, but we're saying this is now your fourth robbery, right? You now have 4 open cases. Perhaps you shouldn't still be on the street. And so he's constrained the ability for his attorneys in court to ask for the judge to hold the person in custody. So the defense lawyer reads this long list of reasons why the person should be released. And then the assistant DA is either sitting on their hands, not allowed to say anything at all, and just saying, we submit to the court to decide, which generally signals to the court, okay, we're not allowed to say anything. Or they say, we submit to release, judge, and can you put an ankle monitor on the person? Well, we all know ankle monitors do nothing. And so he wants you to believe that it's only the judges doing this, but the judge is looking to the attorneys to make the argument. And the argument is not being made by the DA's office. And so when a judge is sitting there, especially the newer judges who are in these courtrooms, they're just hearing the laundry list of reasons why the defendant should be out, and the assistant DA agreeing to the release or not saying anything. And so they're saying, well, okay, if both sides agree he should be out, then I'll let him out.
And that's what I have to do. Right. I am going to, I have about 100 more questions for you, but we are like overtime now. So I'm going to say, anybody who wants to stick around for a few more minutes, we love to have you. This has been such a great discussion. I'm going to go to the questions, the people who have raised hands, and we might be able to also have a little bit of time to take a few things from the chat. But Jorge, I think you had your hand raised first, if you want to ask a question.
Yes, assuming that there will be a change, or we will vote for a change of a new DA, what should we expect in terms of change? I mean, what should be the number 1 or 2 critical components that we expect from a new DA to change, and how to change this the system as it is today?
Yeah, and that's a fair question. I think first, you need somebody that actually knows how to do the job. You've got to have somebody with experience who understands the nuances of being a prosecutor, and that doesn't take this one size fits all approach to prosecution, because it doesn't work. It doesn't work if it's in the punitive form, and it doesn't work if it's in the non-punitive form. Every single case and defendant have to be addressed for their individual circumstance. And that's what you need, is a DA who's willing to do that, who's willing to return discretion back to the DA's office and say, look, we want to be trending in a certain direction, but there are sometimes cases that present us with facts that don't fit into that framework, and we're not afraid to deal with those people on their individual basis. And so that would address, I think, a lot of the issues that we have now with repeat and chronic offenders being released back out onto the street within days. We need somebody that's not going to abuse these collaborative court and diversion programs, who's going to restore back to it the structure that it used to have. And I just want to explain really quickly that about 2/3 of the DA's office is now managed by former public defenders. One of whom was brought over to manage the collaborative court unit. That person did away completely with every single criteria that we had for how someone was eligible for these court programs, and whether or not they could stay if they reoffended while they were out, or didn't show up and do what they were supposed to do. And so they've been so watered down that they're actually no longer having any benefit to the offenders that are in them. And they're actually doing a disservice to our community, because these people are out in the community, and rather than getting treatment, most of them are reoffending. And so we need someone who's going to restore order back to that unit within the office, so that we can really take back control of the situation of who's being, out in the community. Oftentimes committing there's a small group of offenders sort of who are creating the most chaos, right? You may have seen a case of somebody who had committed 28 burglaries, residential burglaries. And so those are the people that they've got to be addressed after burglary number 1 or 2.
Thank you. I have, if you don't mind, one or two more quick questions. One, have you seen in your experience under Boudin, the office taking violent felonies and reducing them to misdemeanors?
What, can you say that one more time?
Have you seen in the office under Boudin them taking violent felonies and reducing them to misdemeanors in certain circumstances? As
far as pleas?
Well, like they'll charge it as a violent felony and then reduce it to a misdemeanor. I read something about that, and I'm wondering if that is true, or maybe you don't know anything about that. Maybe it happened.
Well, like I said, I gave the example of the case that was referred to diversion, the carjacking case. There are other cases. I think I wouldn't say necessarily the most violent cases. Sometimes what they're doing is allowing them to plead, if it's a robbery, they're allowing them to plead a robbery, but they're just putting them on probation with the few days credit for time served. So it may even show up as the appropriate charge on their record, but there's just no accountability for it. There's no consequence. And so that, really is no different than giving someone a misdemeanor. It has the effect because it's on their record, but for them in reality, right, when you're a 20-year-old and you're saying, well, I took a quick plea and I got out, right? Or I was already out, and they're not making me do any programming. They're not making me, right, engage in anything or sending me to jail. To them, it's no different.
Right. Okay. Um, and can you talk just for a second about the way that I feel most DAs that I've experienced in my lifetime in San Francisco or other places I've lived, I might not even known who the DA was. Like there's not been a lot of real sort of press or marketing or is this unusual, the amount of public speaking and sort of PR that Chesa does as a DA?
Um, so it is more than what we've commonly seen. I mean, some people would attribute it to the fact that he's facing a recall. And so he's just garnering more attention that way. But Chesa appears to be a DA who really emphasizes having press conferences. Even more than what I saw with George Gascon when he was in San Francisco. And one thing that I will note, in addition, not only to just doing the press conferences, but it's what underlies the reason for the press conference. And I've been told by other colleagues who have left the office that Chesa has in particularly tried to take credit for investigations and not allowed cooperation with the police for the sole purpose of not allowing the police to take any of the credit for these investigations. In the case of the woman stealing from Target, the loss prevention officer was instructed by an investigator from the DA's office not to call the police, actually, was instructed to call the DA's office when that woman came in to steal, just so that the DA's office could sort of take the credit for that investigation. And so this does appear to be a unique circumstance where he is trying very hard to garner a lot of media attention.
Thank you. Peter, you have your hand raised and then we will wrap it up. Peter, if you're talking, you're on mute.
Appreciate it, and very much appreciate you, Brooke, and everything you've shared with us today. You've been terrific. And this is maybe a tough question. Maybe you can't, I'm not sure if you can answer this, but where does the line get drawn? Because I know you said you believe in reform. I believe in a certain amount of reform. But if someone breaks into a car, it's still a violent act. If someone comes out of their car and knocks someone, off their bicycle and beats them up, it's a violent act. If somebody breaks into somebody's home and robs them, that's a violent, act. So I guess I'm just asking, like, where do you feel the line is drawn as to accountability and actually putting people away and putting them in jail and versus letting them be free? And I know that's kind of a loaded, big question, but I'm just curious what your thoughts are there, because I respect you and your thoughts and opinion. Because I think for a lot of us who are seeing all this happen on the streets, it's like, where does the line get drawn? So anyway, that's a fair question. It's one that as a prosecutor, you ask yourself every single day that you do this job, right? You look at a case file and you look at someone's criminal history and you say, in my view, when is enough enough? Right? Have we given you chances before? Have we offered you the ability to change your life before? Have you taken advantage of it or have you not? I've had defense lawyers say, well, this is their first offense. And that first offense is pointing a gun at somebody's head, pistol whipping them with it even, and stealing their purse, an elderly woman. And I say, I get it. It's their first offense, but they picked the biggest bull at the rodeo to ride. And so I'm stuck here, right? There has to be a consequence for that particular type of action. And so like I said, it's a question you wrestle with as a prosecutor day in and day out. And so that's why it's important to have a leader who has a vision for what those boundary lines are. Working for Gascon when he was here, he took violent crime very seriously, right? We had a lot of problems with auto burglary and those kinds of things, and those probably should have been addressed a little differently. But there was a line,
And that doesn't mean that you simply say, okay, well, if you commit a robbery, you go to prison, because that's not always the answer either. I've given those second chances, right? And when I say second chance, that sometimes means a 2-year. I've even sent somebody who committed armed robbery to a 4-year residential program, not for drugs, but for literally just rehabilitating your life, where they could not leave for 4 years. Just like you can't leave jail, you could not leave there. And he had to wear an ankle monitor all 4 years. And that program, the second he walks out of that door early, who to call? Because some people, when you talk to them and you flush it out, and we have people in the office capable of doing that, do understand the seriousness of what they did after they've had to sit for a while. And that gentleman had already been in jail for several years before we made that agreement. And they're saying, no, I want something different. And so I'm willing to do the work. But sadly, there's a lot of people that aren't. And so the line has to be violent crime, which there is a category actually in our statutes that denotes what is violent and what's nonviolent. And also chronic offenders. We have to be able to deal with them appropriately. We cannot let people, right, break into cars over and over and over again with no consequence. We can't let people burglarize stores with no consequence repeatedly. There has to be a line of demarcation. Drugs, that's another thing. You know, I handled a fair amount of drug cases in my time, and first offense, it's like, look, let's try to let this be your wake-up call. Don't come back here. If you come back here though, it'll be a different story. And when they come back again, you have to deal with them differently, right? If you condition them that the only response is going to be constant release and probation, they're just going to keep doing it. Yeah. And so that's the best answer I can give. There's no.
That's great. I appreciate I very much appreciate your response. That makes total sense. So thank you very much.
Yeah, I do too. Just the idea that it's an everyday thing that weighs on you, that you want to do the right thing in each specific situation. That's actually really helpful to hear. I am going to call it a night, even though I could ask you 100 more questions. Brooke, thank you so much for being here. I'm wishing that we had someone for you to debate. I was really looking forward to an actual debate, because I think that is the best way that we could come to clarity on what is really happening in our criminal justice system and what is really happening with the DA, and why this recall effort is happening, and why people are passionate on both sides. As Danielle from the League of Women Voters said, it's a hot button issue. So I was really looking forward to that, but I'm glad that we could, do a little research and bring in some of his points and have a discussion involving those points. I really appreciate you enlightening us and educating us. Thank you so much. Thank you to everyone who's attended. It is amazing. I think at one point we were up to like 98 people on here. So thank you all for coming, being interested and active, civically engaged. So grateful. And we will see what happens going forward. So thank you so much.
Thank you. Thank you for having me.
Absolutely. It's our pleasure. Good night, everybody.